Good morning, this is your Kelso Report for Wednesday, October 5th, and I'm your host, Clark Kelso. There remains significant tension between the federal laws that criminalize the possession and distribution of marijuana and the implications of California's decriminalization of the possession and cultivation of medicinal marijuana when done pursuant to a physician's recommendation. The basic principle that California may decide for itself whether to criminalize something that is made criminal by federal law is, I think, well understood. But what happens if a state or locality goes beyond mere decriminalization and begins to enact a comprehensive regulatory program around activity that is criminal under federal law? Does that go too far? Well, that was the question before the 2nd District in Pack v. City of Long Beach, where the court considered a challenge to a city ordinance that went beyond simple decriminalization of medicinal marijuana. In fact, the City of Long Beach had enacted a comprehensive regulatory scheme by which medical marijuana collectives within the city are governed. The city charges application fees, holds a lottery for permits, and issues a limited number of permits. Permitted collectives, which must then pay an annual fee, are highly regulated and subject to numerous restrictions on their operation. In light of these facts, the 2nd District held that to the extent the city ordinance actually grants permits to collectives as lawful businesses, the ordinance was preempted by the Federal Controlled Substances Act. Now, under federal law, marijuana is treated as a Schedule I controlled substance, which means its possession and distribution is criminal conduct. And even a doctor's prescription for medical use does not make it legal. It is illegal to maintain any place for the purpose of manufacturing, distributing, or using a Schedule I controlled substance, and the only exception to these federal prohibitions is the possession and use of marijuana in federally approved research projects. The Federal Act contains an express preemption statute which provides as follows, quote, "No provision of this subchapter shall be construed as indicating an intent on the part of the Congress to occupy the field in which that provision operates, including criminal penalties, to the exclusion of any state law on the same subject matter which would otherwise be within the authority of the state, unless there is a positive conflict between that provision of this subchapter and that state law, so that the two cannot consistently stand together," close quote. It is quite clear that this provision rejects what is known as field preemption, where Congress's intention is to occupy an entire field of regulation. Instead, the 2nd District held that this statutory language embraced both conflict preemption, where simultaneous compliance with both state and federal directives is impossible, and obstacle preemption, where the challenged state law stands as an obstacle to the accomplishment and execution of the full purpose and objectives of Congress. Now, the key then to the 2nd District's decision is the distinction it draws between merely decriminalizing the cultivation, possession, and use of marijuana for medical purposes, which a state or locality may do, and enacting a positive regulatory scheme that actually licenses, permits, and extends the legitimacy of the law to organized, large-scale cultivation and manufacture of marijuana. According to the 2nd District, a state or local decision not to criminalize an activity is one thing, but state or local laws that not only legalize, but positively authorize and permit activity that is criminal under federal law goes one step too far. Accordingly, the court held that the city ordinance that authorized permits for marijuana collectives was preempted by the Federal Controlled Substances Act. This is a close call, it seems to me, and a good case for possible review by the California Supreme Court. Our one-liners for today. First, a habeas case. In Carrera v. Ayers, the 9th Circuit, in a split decision, affirmed the district court's denial of the petitioner's ineffective assistance of counsel claim arising out of his conviction in 1983 for murder. The ineffective assistance claim arose out of the defense counsel's failure to object to allegedly group bias-based peremptory challenges that removed 6 Hispanics from the jury in a murder case where the defendant was Hispanic and the victim was white. The problem with the claim is that the prosecutor had reasonable, non-race-based reasons for removing 5 of the Hispanics from the jury. 2 Hispanic jurors sat on the jury, and another Hispanic was an alternate juror. There was no clear reason from the record for striking the 6th Hispanic juror, although the juror was disabled and lived far from the courthouse, so it is plausible he was stricken because of the hardship of the long commute. In any event, the majority held that on this record, the petitioner failed to satisfy its heavy burden under Strickland to establish ineffective assistance. Next, an evidence holding in People v. Larkins, where the 4th District affirmed the defendant's conviction on 5 counts of second-degree commercial burglary, 4 counts of receiving stolen property, and 1 count of identity theft. The convictions arose out of a series of burglaries from lockers at various fitness gyms. One of the witnesses, a loss prevention manager for one of the gyms, testified that he recognized the man in a security video from one of the clubs as defendant, because he had seen defendant in 20 to 30 security videos from other clubs. The defendant objected to this testimony on foundation and speculation grounds, arguing that since the witness had never previously seen the defendant, other than in videos, he should not be permitted to testify that the man in the videos was the defendant. The 4th District held that it didn't matter whether he had seen the defendant before viewing the videos, particularly since the jurors themselves were able to test the witness's opinion, since the evidence included still photos taken from some of the videos, and the jury actually viewed 3 of the 20 to 30 videos themselves. Next, we have an insurance coverage case in Fresh Express Inc. v. Beasley Syndicate. The 6th District reversed the trial court's overbroad interpretation of an insurance contract that protected Fresh Express, which is in the business of selling bagged fresh spinach and other leafy greens, from losses resulting from an accidental contamination of its product. The losses occurred when the FDA issued an advisory regarding an outbreak of E. coli that was possibly linked to consumption of bagged fresh spinach. Fresh Express in its spinach was not the source of the outbreak, but they lost sales nevertheless. The insurance policy covered losses from accidental contamination, but that was defined as, quote, error by Fresh Express in the manufacture, production, processing, preparation, or assembly of any insured products, which causes Fresh Express to have reasonable cause to believe that the use or consumption of such insured products has led or would lead to bodily injury, close quote. There was no evidence that Fresh Express's losses resulted from any error at all by Fresh Express. So the 6th District held the losses were not within the scope of the insurance policy, and the court dismissed the case. Next, a Section 1983 case in Kirkolas v. City of San Jose. The 6th District reversed a trial court decision which had granted the city's motion for summary judgment against the plaintiff's Section 1983 action, which alleged that a police officer had fabricated evidence and committed perjury at a preliminary hearing where the defendant was bound over for trial. The underlying investigation involved an allegation that the defendant had raped a neighbor who was developmentally disabled. Part of the claim was that the rape occurred on a blanket owned by the plaintiff. A lab report indicated that the only substance on the blanket was a blood stain that belonged to the plaintiff. But an investigator had prepared a ruse crime lab report indicating that plaintiff's semen had been found on the blanket, apparently intending possibly to use the ruse crime lab report in interrogating the plaintiff. Although the ruse report was never further used in the investigation, the investigator actually used the ruse report as the basis for his testimony over a year later at a preliminary hearing, that there was semen on the blanket. Ultimately, defense counsel in the criminal prosecution discovered the discrepancy between the ruse report and the real lab report, and the prosecution decided to dismiss the prosecution in its entirety, the officer claiming he had just forgotten. Plaintiff's Section 1983 claim was filed shortly thereafter. The 6th District held that the complaint adequately alleged a violation of due process in light of clear Supreme Court holdings, that the knowing use by a prosecutor of perjured testimony or the deliberate suppression of evidence favorable to the accused is so egregious and outrageous that it shocks the contemporary conscience. The court rejected the city's arguments that there was no violation because he was never convicted and was only briefly incarcerated. Being held over at the preliminary hearing stage was a sufficient injury to support the plaintiff's claims. Finally, we have an issue involving public employment of police officers. In Lanigan versus City of Los Angeles, the 2nd District held that a waiver of the Public Safety Officers Procedural Bill of Rights Act, known as POBRA, is permissible when a police officer is subject to a disciplinary action and, as part of the settlement of that action, agrees to resign if similar misconduct charges are upheld in the future, without pursuing an administrative appeal. The officer in this case argued that his waiver of the procedural protections of POBRA was contrary to public policy. The 2nd District disagreed, holding that a peace officer protected by POBRA may waive those protections when faced with disciplinary proceedings, provided that any settlement is a voluntary and knowing act done with sufficient awareness of the relevant circumstances and likely consequences. Well, that's it for today's Kelso Report. Have a great day in the law.